So the state of New York's new concealed carry law, which bans concealed carry in churches, was just struck down in federal court. So let's talk about this. But real quick before we jump into this video, if you agree that New York's new concealed carry law clearly violates the Second Amendment, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Kershaw Knives. Kershaw produces a broad range of knives to meet everyone's needs. From a $20 Walmart knife for a new owner to a $200 US made automatic knife, Kershaw has your needs covered. One of Kershaw's top goals is to provide a value-packed product backed by a limited lifetime warranty regardless of your current budget. So I highly recommend Kershaw Knives. I carry one of their knives every single day with my EDC. And right now, if you go to their website and use the code SCHOLAR20, you can get 20% off of your order that's site-wide, plus free shipping on orders over $100. And that offer lasts until December 1st. So thank you again, Kershaw Knives, for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we'll be discussing a big win coming out of the state of New York, where a federal court judge just struck down a piece of New York's new concealed carry law that passed in defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association v. Bruen. The case we're going to be talking about in this video is called Hardaway v. Negrelli. In this case, District Court Judge John Sinatra just ruled that the New York law, which bans concealed carry in places of worship, does in fact violate the Second Amendment, and therefore he just granted a preliminary injunction which halts the enforcement of this aspect of this new law. This case arose out of the state of New York's new law that passed in response to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. In Bruen, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. However, despite that Supreme Court decision, the state of New York rushed through a new law called the Concealed Carry Improvement Act, also known as the CCIA. Instead of rolling back their concealed carry laws post-Bruen, the state decided to double down on gun control and created a scheme that was even worse than the one that existed prior to Bruen. For this case, the relevant portion of the new law made it so that a person is guilty of criminal possession of a firearm when that person possesses that firearm in a place they know is a sensitive location. This law then went into the definition of a sensitive location and added into that definition any place of worship or any place of religious observation. So in this case, New York was sued by Reverend Dr. Jimmy Hardaway Jr. and Bishop Larry Boyd, along with two other 2A organizations, which included the Firearms Policy Coalition and the Second Amendment Foundation. In this case, the plaintiffs challenged specifically that place of worship sensitive location ban. In this case, after filing the complaint, the plaintiffs also filed and requested a TRO and a motion for a preliminary injunction. The last time we talked about this case, I informed you that the judge did in fact grant the plaintiffs their request for a TRO. Now, like I mentioned, a TRO is simply a temporary relief. It's a simple temporary placeholder, and the ultimate goal is to get the preliminary injunction. Well, Judge Sinatra in this case, that same judge, just granted the plaintiffs their request for a preliminary injunction. In reaching his decision, he used a lot of the same language and analysis that he used in the prior granting of the TRO. And that is because, like I mentioned, the standards to be granted a TRO is similar for the standards to be granted a preliminary injunction. That is also why if a court grants a TRO, it's pretty positive and it's a good indicator that the judge will also later grant the preliminary injunction. And that's why it's always a big deal when a court does in fact grant a TRO, because it kind of just signals what's going to happen with the case later on. In this decision, Judge Sinatra stated once again that ample Supreme Court precedent addressing the individual's right to keep and bear arms, from Heller and McDonald to its June 2022 decision in Bruen, dictates that New York's new place of worship restriction is equally unconstitutional. In Bruen, the court made the Second Amendment test crystal clear. Regulation in this area is permissible only if the government demonstrates that the regulation is consistent with this nation's historical tradition and sufficiently analogous regulations. As set forth below, New York fails that test. The state's exclusion is instead inconsistent with the nation's historical traditions, impermissibly infringing on the right to keep and bear arms in public for self-defense. This history and tradition framework that he's mentioning comes directly from the Bruen decision, where Justice Thomas stated that, in keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with this nation's historical tradition may a court then conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Using that standard, Judge Sinatra stated, the state argues that the place of worship exclusion complies with Bruen. The state cites 1870 to 1890 enactments by 4 states, Texas, Georgia, Missouri, and Virginia, and the territories of Arizona and Oklahoma that contained place of worship firearms restrictions. That does not carry the state's burden. Judge Sinatra points out that this type of argument of a few outliers was also presented to the Supreme Court in the Bruen decision, but the Supreme Court there found that a few laws that may have existed on the fringe of society is not sufficient support for this type of a ban. Instead, the government must show that the regulation was consistent with this nation's tradition, i.e., essentially that it was prevalent at the time. Judge Sinatra goes on to state in this order that nevertheless, the state relies on a few laws from the late 1800s to insist that a relevant tradition exists. Bruen anticipated this argument, rejecting the relevance of an outlier analogous law in state court decisions. The court stated that it would not give disproportionate weight to a single state statute and a pair of state court decisions. Therefore, in this case, Judge Sinatra found that 4 states and a couple territories that had some type of worship restrictions dating to the 1800s is not sufficient enough to justify what the state of New York is trying to do here with this place of worship restriction. Also, there's another issue here that the judge points out, and that's the fact that the state of New York presents history dating to the 1800s, which Bruen says is not relevant. Bruen requires history dating to the time of the ratification of the Second Amendment, which is 1791. However, a lot of these states, like the state of New York, are having trouble finding any type of history that can justify these types of bans, so they're trying to rely on later history as some sort of support. But here the judge in this case did the right thing and absolutely rejected this later history as insufficient and said that no, this 1800 history, as per Bruen, is not relevant, and therefore it's not a good enough support for what you're trying to do here with this new CCIA law. Then the judge in this case granted the preliminary injunction and also denied the state's efforts to limit the preliminary injunction to only protecting the named plaintiffs. He found that since this law was unconstitutional, it must be enjoined from affecting all law-abiding people who wish to engage in self-defense in these types of locations. He also rejected the state's request that he stay his decision for 3 days so that they could appeal his decision up to the Second Circuit. He found that there is significantly more harm that would be suffered to the public at large by allowing this unconstitutional law to remain into effect even for those 3 days. He stated, legislative enactments may not eviscerate the Bill of Rights. Every day they do so is one too many. Therefore, he granted the preliminary injunction and it went into effect. It was not stayed for the 3 days like the state of New York wanted. So this is a solid win coming out of the state of New York. You have another federal court judge in New York finding that an aspect of the CCIA is clearly violating the Second Amendment and is also not adhering to the test outlined by the New York State Rifle and Pistol Association v. Bruen decision. So I will keep my eyes on this case. If I get any more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.